Welcome to today's program titled California Wildfires, Managing Key Employment Issues Amid Emergencies. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, later in the presentation, we will read the CLE attendance verification code. Please write this code down, as it will not be reread and it is required on the CLE credit request form. During the program, you will see a slide with a QR code that you may scan to access and submit your request for CLE credit. You can also find a link to this form in the connection details email you received this morning. Copies of the webinar recording and materials will be distributed to all attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw, LLP for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to welcome our speakers for today's program. Ryan McCoy, a partner in our San Francisco office, Ben Conley, a partner in our Chicago office, Alana Maradi, counsel in our San Francisco office, and Kathy Feldman, an associate in our Los Angeles office. You will hear from each of them shortly, but to kick things off, I would like to turn it over to Alana to get us started with Cal OSHA protections. Alana, please go ahead.
All right, thank you, and thanks everyone for joining us. Wish it were under better circumstances, but here we are. So kicking us off on Cal OSHA protections, there is a Cal OSHA wildfire smoke standard, and so the biggest question we've been getting in the safety space is whether this standard applies right now for employers who are affected by the fires. The applicability of it depends on the air quality index for particulate matter 2.5. That's like fine particles. It kicks in when the PM 2.5 is 151 or greater, and that's regardless of the air quality for other pollutants. So right now, interestingly, even though the air quality is not great in Los Angeles, last time I checked, it's not even close to 151 for PM 2.5. So this standard right now is not going to be applicable to employers. Air quality can change very quickly. So what's important is that if you could reasonably anticipate that employees may be exposed to wildfire smoke, as employers, you should be monitoring the air quality. So even though we're not at 151 or greater right now, you want to be monitoring. There are a number of exemptions. The biggest one that most of our clients would be interested in is enclosed buildings or structure in which the air is filtered by a mechanical ventilation system. So like most office spaces are going to be exempt. There are also exemptions for enclosed vehicles if there's air filtration. Employers can also purchase and monitor air quality themselves rather than relying on the EPA's air quality website. So if you can demonstrate that the air quality at your place of employment isn't 151 or higher for particulate matter 2.5, then you're also exempt. There's also an exemption for those employees exposed above the threshold, but for less than an hour in a workday. Firefighters engaged in wildfire fighting are also exempt. Next slide, please. So what do you need to do if your workplace is covered? Certain requirements will kick in. You're going to have to continue to monitor the air quality. There's certain information that you have to provide to employees on what the current air quality index is and what protective measures are available. You need to encourage employees to report worsening air quality or symptoms. There's training that you have to provide. And then you have to implement what we call in the safety world a hierarchy of controls. So first you look at engineering controls, which are like changes to the physical environment, like installing portable air filtration, increasing ventilation, things of that nature. Then you look at administrative controls, so changes to like work schedules, having employees work from home, that sort of thing. And then PPE, which is personal protective equipment. So that's where an N95 masks come in. If you can't get employee exposure to particulate matter below 151, then you need to provide N95 respirators. The important piece there is that you're providing them to use on a voluntary basis. You can encourage employees to use it, but don't require them to use it. If you require employees to use a respirator, you trigger the respiratory protection standard of Cal OSHA, which means that you would have to obtain medical clearance and do a proper fit check for employees before they wear those respirators. So again, the key is just make it available voluntarily. I should also say before we move on to the next slide that a lot of employers even now are purchasing and making N95s available. That is, if you can do it, a great idea, even though we have not triggered applicability of the standard right now. I think a lot of folks are aware that, you know, even if you're not at, say, particulate matter 2.5 above the 151 index number, there are, for instance, like toxic gases that don't get considered when you look at a PM 2.5 index number. So you can still be exposed to hazards in the air outside of particulate matter 2.5. So again, you are free to do this, and many employers are providing N95 masks. Just again, make sure that you're not requiring employees to wear them. Next slide.
Thanks, Alana. And so shifting gears briefly, one of the most common questions that I think we've been receiving is an overwhelming show of support from employee bases and from employers and saying, how can I help, right? What can I do? We have affected colleagues. What are the steps that we can take as an organization, or what are the steps that we can help facilitate for our employees to help people who are in need because they've lost their home, displaced, et cetera. And for better or worse, this is a disaster on the heels of a series of other disasters that have impacted either specific regions or the nation as a whole when it comes to COVID. And so there is somewhat of a benefits playbook that we go back to in these circumstances to outline the options or common benefits that employers might offer to help their employees or to allow their employees to help other employees. And to be clear, I mean, one option is always, you know, anybody can give anybody money, right? Employees can give each other money, employers can give employees money, but the federal government has structured a series of different types of benefits that allow you to do so on a tax preferred basis, which sort of enhances the value of the money being provided to the employees. So I really want to kind of break this down into three general buckets. The first being employer aid to affected workers. And there's a section of the Internal Revenue Code, Section 139, that allows you to establish a program wherein you provide money to employees on a tax-free basis pursuant to a federally declared disaster. So this is just a straight up payment of cash with no tax consequences at the federal level. I should note that state taxation can vary, and notably in California, the payments could still be subject to unemployment and SDI withholding, but pretty powerful vehicle otherwise. There are no restrictions on the size of the amount of money you're allowed to give to affected individuals, although you should have a system in place to ensure that the amount is reasonable or necessary amounts to pay for personal, family, living expenses, etc. It's not supposed to be an income replacement benefit. There are potentially other avenues to deal with that. And it's not supposed to cover things like medical expenses, because if you're doing that, then you're creating an ERISA plan, which has a whole host of other problems. I mean, it's fine, but other potential issues there. So what employers typically do is structure a program whereby an employee can apply and demonstrate that they've incurred expenses, and then employers can reimburse them accordingly. They can't be in expenses that are otherwise reimbursable by other sources like insurance. So this would be one gatekeeper function you'd have to take care of here. And then the IRS has also opined that in certain circumstances, if the amount that you're giving them is an amount that could be reasonably assumed to be an amount that any given affected employee would have incurred, you don't actually have to have that gatekeeper function. So during COVID, we saw some employers do this and give employees something like $500 tax-free because you could reasonably assume that they were going to have those kinds of expenses as a result of COVID. So that's sort of category one, employers giving money direct. Category two is how can employees help other employees? And we've seen employers implement two different types of programs to address this. One would be an employee assistance fund. So again, typically if an employer gives an employee money, other than the 139 plan, or if an employee gives another employee money, it's a tax, the employee who's giving the money is taxed on and the employee who's receiving the money is potentially taxed on it. But what some employers are doing is setting up a charitable organization to allow employees to donate money on a tax-deductible basis, and even employers could put money in on a tax-deductible basis, and then the payment from the charitable organization could be provided on a tax-free basis to affected individuals. This one's a little bit more involved because it does involve standing up a 501c3 organization and monitoring that pursuant to a board. Monitoring who's applying and what expenses qualify. But this is something that employers can set up and sort of implement on a continuing basis. Seyfarth Shaw has something like this that's been around since before COVID. But anytime there are natural disasters, incidents like this, etc., it's a good tool to be able to facilitate that immediate ask, which is how can I help impacted people. Another program that became relatively popular during COVID are PTO banks. And there is another, again, the situation you're dealing with here is employees say, well, I want to give money, or I want to give PTO to affected people who have to go and, they're in a different state or whatever the case might be, and they're not able to work, but they have potential limits on what their PTO might be. And we're going to talk about PTO a little bit here later in the presentation. But the issue would be that in the absence of structuring one of these programs, you would have a circumstance in which the employee who is giving away the PTO is still taxed on that PTO as if they had used it. So if you set up a disaster leave sharing program, you can effectively allow employees to donate PTO into a leave sharing bank that can then be tapped by affected people who have been impacted by the natural disaster, and again, affords tax preferred treatment in terms of how you structure that. And then the final category that I want to talk about here are how can employees help themselves, right? Impacted by the fires. And oftentimes workers' biggest source of disposable income, although it's not really accessible, is your 401k plan. And typically if you take some 401k plans permit hardship withdrawals. If I have a hardship, I can take money out of the plan. Problem is you're taxed on that distribution, and there's a 10% penalty on that amount. But if your plan provides for it and you have a distribution pursuant to federally declared natural disaster, you can avoid that 10% penalty up to an IRS cap of $22,000. So if your plan provides for this, or even if your plan doesn't provide for this and you amend your plan to provide for this, this can be a way to allow employees to tap that asset, their 401k plan, to get their hands on urgently needed emergency cash. Final point I'll make before I hand it off here is that typically what we see in the wake of natural disasters is that eventually the IRS, Department of Labor, et cetera, issue a bevy of guidance that effectively relieves impacted people from otherwise complying with deadlines. So when we talk about deadlines, there's a lot of things here, but one most common one is like electing COBRA, right? I had a termination event and I was going to elect COBRA. I had 60 days, but because I was impacted by the fires, I didn't have the ability to do so. Or had a HIPAA special enrollment event because I had a baby and I failed to enroll the baby in the health plan in a timely fashion. We fully expect that type of relief will be issued here. You don't necessarily need to wait for it. You can probably reasonably assume it's going to come, but we fully expect that eventually that guidance will be issued, and what that allows is flexibility on those deadlines to allow employees to make those elections potentially outside of the otherwise required window. Okay, next, I'm going to hand this off to another speaker here. If we can go to the next slide.
Thanks, Ben. Appreciate it. I just wanted to briefly touch on some of the wage and hour issues that we have been seeing as a result of the fires over the last couple of weeks, namely issues relating to compensation, reporting time pay, some of the local ordinances that are at play as well. First, it's always critically important to make sure that all of your employees, whether or not they are hourly or salaried, that they are getting paid appropriately for all of the hours worked. The rules haven't really changed for hourly and non-exempt employees. We have to pay for all hours actually worked, whether or not they are at the office or remotely. Commute time, generally not compensable. And that's true even if the commute time is going to increase as a result of the fires and the traffics and the shutdown. And there are some exceptions to that general rule, namely if the employer requires its employees to meet at a designated place, but still generally speaking, the commute time is not going to be compensable. Now, what happens if the office is closed or the employee is unable to get to the workplace? For hourly employees, if they're not actually working, then we do not need to pay them. But if the employer wants to set up a remote work arrangement with that employee, we have to make sure that we have clear communication with that employee and making sure that that employee is tracking their hours worked to ensure that they are getting paid accurately. So it really depends on the situation. Some employers are still asking their hourly employees to work from home. We have to make sure that they are getting paid for all of those hours worked. But if those same employees are not being asked to work because the office is closed, the facility is closed, the store is closed, the restaurant is closed, they do not need to be paid for that time. For the salaried employees, the exempt employees who report to work but are sent back home by their employer, they still have to receive their full salary for that week. If they work one day out of the work week, generally speaking, they have to get all of their compensation for that week. If they are working remotely during that week, otherwise not coming into the office as usual, if they are still working, either checking email, making phone calls, setting up meetings, coordinating efforts from other employees, they still need to be paid for that entire work week. Generally speaking as well, for salaried employees, if they're unable to report to work due to transportation difficulties as a result of the fires, they're considered to be absent for personal reasons if the office is otherwise open. And they do not have to be paid for those days if they are unable to report to work. However, if they are still being asked to work remotely from a home office or otherwise, they still need to be paid for that time working. And just a flag, deductions for partial day absences generally still are not permitted for those salaried employees. Next slide, please. One of the biggest issues that we've seen over the last couple of weeks is reporting time pay. For hourly employees, generally speaking, if an employee is asked to report to work, but they're not provided their full day schedule, they have the entitlement to reporting time pay, which is at least 2 hours of compensation. But the statute itself has an exception for acts of God or other causes not within the employer's control that interrupt the work. Here, the fire, unfortunately, is going to be under that exception for reporting time pay. So if an employee shows up to work and they are sent back home as a result of the fire, then generally speaking, that's going to fall under the exception for the reporting time pay. Now, the difference there is if the business is closed at the employer's discretion and not as a result of the fire, or if the civil authorities recommend work not continue, or if the power goes off. If the business is closed at the employer's discretion, then the general reporting time pay rules still apply. Other unfortunate issues include payroll records. We have heard of several instances where payroll records have been lost, and we no longer have records of the employees' hours worked during periods of time. And the best way to try to remedy that situation is to try to recreate what those hours worked were. And there's a number of different ways you can do that. You can talk to the employee, you can talk to their manager. If you have electronic records, such as card swipes or logging in and out of their computer, that can be helpful to recreate the employee's day if the payroll records are lost. If you're using physical timekeeping records and those are lost as a result of the fire, then there are measures that you can take to try to recreate those records to make sure that the employee is paid accurately and that you are meeting your obligations to keep accurate payroll records. Final issue I want to go over is Los Angeles's Fair Workweek ordinances. This is the ordinance that was passed by the city of Los Angeles. It generally requires covered employers to provide employees with notice of schedules at least 14 days in advance. However, the city did confirm that the fire is going to be an exception to the ordinance. So for the time being, the Fair Workweek ordinance does not apply to this situation. And I will kick it off to Kathy.
Thanks, Ryan. So we're going to pivot and talk about leave and time off in the event of natural disasters like the one we're obviously currently in. There are a couple of different ways that you can provide your employees with time off from work. Some that seem very innate and some that there need to be some specific conditions or circumstances. So it will still be an employee by employee, case by case consideration for a lot of these. Starting off with SIFRA and FMLA, if an employee has a serious health condition that's been caused or exacerbated by the fires, by a natural disaster or a family member, then they could be eligible for FMLA or SIFRA as they would otherwise be in the event of those types of conditions. So, and we want to keep in mind that this includes mental disabilities as well. If an employee's got chronic stress or anxiety that's flaring up because of whatever else they might be dealing with related to the fires, that could be a condition that qualifies for SIFRA or FMLA leave. Similarly, paid sick leave, given the breadth of what it covers, would apply and would be available to employees who are experiencing any exacerbation or new medical conditions, mental or physical, related to the fires, as well as preventive care or diagnosis. If you've got someone that's in a compromised population, they have asthma, they've got any one of a number of conditions where they're susceptible to smoke and that is going to pose some health risks for them, sick leave would apply in those situations as well. Additionally, specifically for agricultural employees, effective January of this year, the California Paid Sick Leave Act now expressly allows those employees who work outside to avoid smoke or other conditions that might be caused by natural disasters, including when their work sites are closed due to those conditions. So that's a new kind of subcategory of paid sick leave that would be available to that specific population of employees. It's important to keep in mind as well that these conditions that we've talked about already that would require SIFRA or FMLA or paid sick leave, they might arise right now, or they might arise in a couple of weeks, particularly when we're talking about SIFRA and FMLA. It might take some time for employees to get some of that documentation. So this is not something that we want to pay attention to just in this week or just in these couple of weeks. We want to make sure that we're keeping this situation in mind in the coming months, depending on what employees come forward with. And additionally, as Ben was mentioning earlier, vacation and PTO time that might be available, that's going to really depend on the employer's policy. We always advise that you're consistent with however you are making that time available. If you're letting one employee use it in the event of the natural disaster, recommend letting whatever employees are impacted use it as well. And if you are creating a new bank of leave for this purpose, make sure you're structuring that carefully. If you're allowing employees to use, let's say, 5 days for any reason, that could end up being subject to California's vacation requirements, which would then need to be paid out at the end of employment. So just make sure that you're thoughtfully putting those policies in place if that's a direction you're planning on going in. Next slide, please. So these two leaves here, these are a little bit more really specifically tailored to situations that a lot of your employees, or at least some of your employees, are likely facing. School and activity leave is something that applies for any employer with at least 25 employees, not just in California, but 25 employees generally. And it's available to anyone who qualifies as a parent. We've got that definition up there as to what is included in the definition of a parent of a child of a qualifying age. But essentially, employees are able to take up to 40 hours of unpaid time off. So we previously talked about paid sick leave, PTO, that's obviously paid categories. Now we're in an unpaid situation, but 40 hours each year in the event of a natural disaster that results in a child not being able to be in school, or if their place of if their childcare provider or their school it has been closed. This leave is also available in other circumstances. So if you do have an employee that's already dipped into this bank for other qualifying reasons, keep that in mind. It's not a new 40 hours that's available to them. And the employee does need to provide notice under this leave requirement as soon as is practical. The other category of leave we'll kind of briefly touch on is emergency service leave. If you've got any of your employees that are working as voluntary firefighters or emergency personnel to combat the fires and resulting situations, they're also entitled to unpaid time off. And I doubt that any of those people are really doing any training exercises right now for that leave, but if you've got at least 50 employees, they would also be able to use up to 14 calendar days a year for training related to those activities, that type of service. Next slide, please. All right, so this is a final note, a little related and a little separate from the leave requirements and considerations. But obviously, again, as we've talked about, the conditions that employees might be experiencing or facing, those could cause a need for a leave or another type of an accommodation currently or down the road in the near or further out future. So keep in mind that we're going to want to engage in those same type of interactive processes with those employees that ask for an accommodation, including if they're asking for a leave of absence, as we would under any other circumstances. And another final note here is that beginning back in January of 2024, California legislature passed an amendment to the wage theft notice, where employers now must disclose the existence of a federal or state emergency or disaster declaration that's applicable to the county where the employee is to be employed. And there's a few exceptions to this, mainly for employees that are under CBAs and some exempt employees as well. But generally, you're going to want to keep track of the fact that the emergency declaration for the LA fires was issued on January 7th. And so that 30-day window as of now, again, we don't know where things are going to go and if other declarations will come down the pipeline. But as of now, based on that current declaration, this emergency disaster should be disclosed to impacted employees within the county between January 7th and February 6th. So we've covered a lot of material. This is obviously a bit of a highlight presentation. If you have specific questions or specific circumstances, certainly reach out to us or any other Seyfarth attorneys. We are here and happy to help in any way that we can. And moving on to the next slide, we've got the CLE code there, the CLE QR code, and the code for today is SS Seyfarth Shaw 2525. That's SS 2525. And we'll leave that up there for a minute or so for you all to capture. But hopefully this was helpful, and we are, like I said, available to anyone who has additional questions about how best to handle this for your employees.